You okay?
Yep,
All right, great. If you'd go ahead and put us on the record.
we are on the record.
Is a time and place set for a hearing in the case of Hiller-Webb versus Southwest Neighborhoods, Inc., case number 20CV 35030. Judge Hodson presiding. Counsel, if you'll go ahead and put your appearances on the record, starting with the plaintiff, I would appreciate it.
Good morning, Your Honor. This is Alan Kessler for both plaintiffs Tyvoll and Hiller-Webb. My bar number is 150209. My co-counsel, Ryan Peck, is on the line but will not be presenting today. Their bar number is 144012.
Okay, great. Thank you.
And good afternoon, Your Honor. This is Simon Huang, WHANG 035282, counsel for Southwest Neighborhoods Incorporated, or SWNI, as we call it.
Okay. All right, well, I'm ready for whatever argument you'd like to make. I've read all of your materials. I think, Mr. Wong, you filed first, so you can argue first.
Well, Your Honor, ultimately this comes down to the 6 Marks factors, and the question before this court is whether SWNI is a public body subject to public records law. And that effectively is the issue that is before the court. As far as well explained in the briefing, when you look at the 6 Marks factors and weigh the totality of the circumstances, what you see is that SWNI, as a neighborhood, as a district coalition, is very similar to the neighborhood associations, which are independent nonprofits that are performing functions that are separate from government. But the big factors that the court would look at in terms of whether it is a public body or not, SWNI simply does not fit under those criteria. It is an independent nonprofit. It is private. It is not something that was set up per se by the government, but rather it was incorporated by citizens in order to be a private nonprofit. One telling case that came up more recent, or was emphasized more recently, was the Lane versus City of Rockaway Beach. That was the case that involved the fire department, and one portion of the case that counsel had relied upon that for the proposition that that what matters is the timing of the public records request, that we should look at the public request back at the time that it was made as opposed to what the situation for, say, SWNI is right now. I think the bigger takeaway from that case is really that in Lane, that the plaintiffs were getting records for the fire department that was prior to September of 1991. Now, the reason that that is important is that what happened in September 1991 is that is when the fire department incorporated as a private nonprofit entity. And so the implication there is that because it's a private nonprofit entity and is incorporated as such, it would certainly not be subject to public records request. So the battle in Lane and Rockaway Beach, Lane v. Rockaway Beach, was really about the fire department's role prior to September 1991, before it had incorporated as a private nonprofit entity. There, of course, the court did find that public records law did apply, and that the fire department was indeed a public body, but or at least not a public body, at least subject to it because of its closeness with the government. But there we're talking about something that is traditionally government function. When you think about fire departments are things that are run by the government. There are so many instances in Lane in which there is employment by effectively the city. The city is paying for the officials, paying for the equipment, deeply involved in the operations of the fire department. We don't have that in SWNI. In SWNI, the day-to-day operations, in fact, the vast majority of the operations are within SWNI's control, but the government doesn't really do anything aside from some of the oversight functions and some of the some of the communication functions, and the oversight is really limited to the funding. The funding is something for the court to consider as well. Even if the court accepts the proposition that that this should be subject to about 2 years ago when the public records request was made, and at that time SWNI was accepting funding from the city. Some 85% of this budget was coming from the city of Portland. Even then, the conclusions that the district attorney had made and what is the proper conclusion of the law is even with funding alone is not sufficient to make something a public body. And there are many, many instances in which there are private entities and nonprofits that receive funding from government, but they don't magically transform into public bodies. Here we have that was really one of the maybe strongest factors in plaintiff's side was the funding back then. Kind of a moot point now, because now SWNI gets zero funding from the city. Now SWNI has no connection whatsoever with the city. The city has distanced itself and effectively disavowed itself from SWNI. And so in terms of the weighing of the merits and also with respect to policy considerations, something else for the court to really look at is that what would be the effect here? What would be the effect if, say, the court were to rule that Southwest Neighborhoods was a public body subject to public records law? Practically, what that means is that if the court does make the ruling, which would be the incorrect ruling as a matter of law, but if the court were to make that ruling and SWNI now had to be subject to fulfilling this public records request, it wouldn't be able to do so. There is no staff on hand in order to make the copies, look up the files, do the operative mechanics that are necessary in order to fulfill the public records request. So in essence, this entire lawsuit really is somewhat of a moot point because they can't get to the conclusion that they had originally sought because of the change of circumstances. So one is kind of a general consideration for the court in terms of what are we doing here and what is the effect of the court's ruling actually going to have in practical real-world applications as opposed to this esoteric theoretical sense of whether it's a public body or not. It's one. And second, with respect to the funding part of it, even with 85% of the funding that was going to SWNI from the city, the district attorney had the right conclusion, which was that even despite that, it's not enough to transform Southwest Neighborhoods or in the other matter that's part of the record for neighborhood associations, that they are not public bodies. There are no employees at all. There were some inferences with respect to some funding that went to certain employees. There was one person who was part of the environmental services that I think did kind of a cross designation. But for the most part, we're talking about a volunteer organization in which there is no government employees whatsoever. And that's something that's very significant with respect to the court's determination of the public bodiness of SWNI. So with respect to funding, control, employees, and the other big one of like, does SWNI make any decisions at all that bind the city, bind government? Do they make any kind of administrative decision-making, policy, anything of the sort that you would expect to see in a public body or in government? And the answer to that is no. It's a one-way street. The government may, for example, fund or withhold funding from SWNI, but it doesn't go the other way in terms of SWNI have anything that SWNI does has any impact or influence whatsoever with respect to how the government must act. And so there's not anything in the record which plaintiffs are providing which provide a significant difference in the underlying law and the underlying decisions by the district attorneys in this area when it comes to neighborhood associations and as it should apply to district coalitions that would allow this court to come to the conclusion that SWNI is a public body and subject to public records law. So there's these pieces that the court needs to consider, but also just kind of the overall gut check in terms of smell like a rose, look like a rose. Here we're talking about a neighborhood association, a loose the district coalition that is SWNI is a coalition of all of these neighborhood associations, which are just citizens who do civic functions as volunteer group under this umbrella, but that has the feel, the look, and the reality of a private nonprofit doing its thing as opposed to government doing their thing. The reason that it feels that way, because that is what the reality is, and there's nothing that plaintiffs have presented which should veer this court from the determination that SWNI is not a public body.
All right, thank you. Mr. Kessler.
Thank you, Your Honor. So my clients were both active in the neighborhood associations, and through that gained positions on the board at SWNI. And in serving in those roles, it became clear that there had been embezzlement that the public wasn't generally knowledgeable about, even though there had been a conviction years ago. And it was clear that some of the board members still on the board were there at the same time. And my clients, rightfully so, thought something was fishy and wanted to investigate, and tried to do so through their rights as board members, and also tried to use the public records law because SWNI was acting in the capacity as a quasi-public entity, a quasi-governmental entity. They were entitled to receive the records of its public dealings and wanted those in order to expose what they thought was likely corruption. Through their efforts, through my client's efforts, SWNI has now been defunded. They brought to light improprieties, and there were hearings at City Hall, and ultimately City Council decided to pull funding from SWNI over the concerns that my clients raised. This is important information that SWNI was hiding. The fact that SWNI was created directly after the statute authorizing the creation of district coalitions, had a negotiated contract within a year that allowed the city oversight of its hiring processes, suggests strongly that the only purpose for creating that nonprofit entity was to fulfill that role that the government had created. Communicating with its citizens is a core function of government. Government needs to be able to communicate its plans and policies so that it can get full engagement. The city of Portland has a slew of policies that are aimed toward equity and inclusion and allowing the public access to the decision-making process. And the way that it effectuates that is through the Office for Civic and Community Life. The lion's share of the budget of that office goes to the Neighborhood Association program, which is administered by district coalitions and business coalitions. Where there is geographical territory where there's not an appropriate business coalition or district coalition, the government fills one in. And that is exactly what happened after City Council pulled the funding for SWNI. The city then created another entity that fills exactly the same governmental role that SWNI had been carrying on for its 70 years of operation or so. The business that this new entity, the Southwest Community Services Bureau, does, the functions of SWNI that now a true government entity, Southwest Community Services, does, is public business, just like that same business was for the decades prior to that that function being transferred. The public records law in Oregon is designed to allow any person to look at the business of government, look at the public's records, and determine whether there's impropriety. And this is exactly what my clients wanted to do. That a government hires a nominally independent organization to fulfill its fundamental government functions doesn't make that a government function and doesn't protect those records from public scrutiny. And that's what's encapsulated in the Marx factors. It's this desire to effectuate the public records law, even where the government may try to subvert the public records law by, in name only, creating an entity to carry on functions, and then to take those out of the public purview. The focus in a public records request is always the records. That's the atom of government information to which citizens are entitled. Talking about where SWNI has come since our clients' public records requests were denied, and then since they filed this lawsuit, that's irrelevant. At the time my clients submitted their records requests, the underlying records were public records, are public records still. It's possible that those records don't exist anymore. If so, somebody committed some misdemeanors. It's possible that there's no staff to go access those records. That's okay. With a court order, we can overcome those practical hurdles. The question is whether my clients were entitled to the documents that they requested at the time they requested it, and then whether they should then prevail in the suit and get the declaration that they're seeking, that the records are public and that they're entitled to them. The defendants want to rely on their bad act. They got themselves defunded. They weren't transparent with the city of Portland. The city council decided to pull their funding. And now the defendants say, oh, look, we don't have that money anymore, therefore we should get the benefit of our bad act and this lawsuit should go away. That doesn't make any sense. Just because SWNI no longer functionally operates doesn't mean that the records it created when it was doing the public business don't belong to the public. And we're still entitled, and my clients are still entitled to get at that. The briefing runs through the Marx factors in some more detail, but briefly, SWNI was created because of the district coalition system embedded in city council and city law. The first factor, the entity's origin, it was created because of government action, not directly by government action, but as a response to it, as expected response to that. The function assigned to the entity goes to the core of democracy. It is a primary government function for the government to communicate with the public its policy intentions and its actions. The entire purpose of the Office of Community and Civic Life is to tell the public what the government is doing and listen to what the public is doing. The city has decided to create a layered network of associations to fill that function, but that doesn't make that not government business. The scope of the authority granted to and exercised by the entity, as in the briefing, and in especially my co-counsel Peck's declaration in support of the counter motion, we lay out the history of the contractual oversight that the city has always maintained with SWNI. And it's clear that the city had power over SWNI because when the city decided that SWNI was no longer trustworthy and no longer could carry on the government functions, it stopped it from doing so. 85% of SWNI's budget went away. It became effectively a non-entity. It stopped doing all of the things that were creating the records that my clients have requested. So it was essential that the government funded that activity for that activity to happen. Similarly, the support, financial involvement, council would ask you to, ignore that SWNI for almost all of its existence, and at the time the records request got 85% of its funding from the government. But I don't think they should have the benefit of their bad act, and it doesn't change the nature of the records at the time they were requested. Nature and scope of government control, again, they had the power of the purse, and they had contractual audit. The city of Portland had contractual power over SWNI. Moreover, the city of Portland promulgated the ONI standards, or the OCCL standards, the standards of community involvement. So there are administrative rules promulgated by the City of Portland that describe how district coalitions need to act. It creates, it gives district coalitions the power to create and to nominate and to de-recognize neighborhood associations under it. Neighborhood associations show up all over city code, especially in terms of land use review, so there are special privileges given to neighborhood associations, and the district coalitions get to decide who is and isn't a neighborhood association, a government function. The administrative rules promulgated require the district coalition to create an appeal process so that if there's a grievance within a nonprofit, one of the neighborhood associations, that grievance can be appealed to the district coalition. And in turn, the district coalition's ruling on that grievance can be appealed to administrators at the city. So there's this entire appellate process that spans from the neighborhood association, is effectively administered by the district coalition, and then has oversight by the city. That's not an independent organization. This is integrated business. And the status of the entity's officers and employees, again, we presented some evidence in the record that the city, at least at certain times, has had selection power over employees of SWNI. So Mark's factors, none of them is conclusive. They're meant to be read in total. The Public Records Act requires that courts interpret public records laws in favor of disclosure. It's not a privacy law, it's a disclosure law. So to the extent that any of this is a close call, the default should be in favor of privacy, or in favor of disclosure. Yeah, the entire purpose behind the Marx factors, behind the analysis of quasi-governmental entities, is that nonprofits and private businesses can be like public bodies, and it doesn't matter for purposes of public disclosure whether or not those records were created at a government entity or an entity that's doing the government's business. SWNI is the latter. Our clients validly requested records and are entitled to them. Thank you, Your Honor.
All right, thank you. Rebuttal.
Well, Your Honor, with respect to the concept of public records law, the idea of transparency is, of course, a good thing. And, of course, public records law are very open here in Oregon. But the entire premise of the idea that rulings should veer towards public records disclosure only applies when the public records law applies. And here, it doesn't apply because the simple fact is SWNI is not a public body. There's not enough factors of the 6 Marx factors that weigh on plaintiff's behalf that veer SWNI that way. And so even if we can believe in this concept of public records and transparency in government being an ideal or being something that is a benefit to society, yes, we completely 100% agree with that. But that is only when a body is actually a public body that is subject to public records request. Here, we just don't have that. We simply cannot. There's nothing that plaintiffs can provide with respect to the functionality that SWNI had that tips the scales in the favor that it is a public body. The big factors that I mentioned and that we briefed on, it doesn't smell like government because it is not government. And so, sure, it's great when government communicates with its citizens, but what does something like Southwest Neighborhoods do? It is a meeting place for the different neighborhoods associations. They send out a newsletter. They provide information and those things. But those are the kind of things that the government is I suppose, can do with respect to a citizen, but what we're talking about is a network of individual neighborhood associations under this district coalition where they can have a place in order to share ideas, in order to get information about volunteer opportunities and things that is part of their function, but it is a private function for a nonprofit. It does not transform into government. If we want to talk about policy, if the court were to rule that Southwest Neighborhoods as a district coalition was indeed a public body, the implications of that then is like, okay, a private nonprofit then is somehow a government body. That means that all of the neighborhood associations would also become public bodies and subject to public records requests. Any independent nonprofit that has any connection with government whatsoever could very well be a public body under their analysis, and that's just not simply the case. There's a lot of connection between independent nonprofits and government. Contracts, communications. Here, the big factors, though, in terms of control, in terms of employment, in terms of funding, but mostly with respect to this idea of control and influence, there's a separation between what SWNI does and what the city does. It's a pretty big separation. The city does not give district coalitions that type of latitude, and that they had set up a law that allows for district coalitions and neighborhood associations to come into being as a means of keeping some of that arm's length, in essence. If the government wanted to do those functions itself, it would have. It didn't. And so that is what led us here with the district coalitions, but it simply is not enough to effectively make a district coalition into something that is government, or even quasi-government enough to tilt the Marx factors. It's just simply, if we follow the law and follow also the analyses in each of the district attorneys' conclusions that they made the right conclusions of law, and plaintiffs don't give us anything that would really shake that.
All right. Anything further from the plaintiffs?
Nothing further, Your Honor.
Okay. All right. I'm ready to rule. I'm ruling in favor of the plaintiffs, and I will explain the basis for my ruling. So this case, as you know, comes to me on cross motions for summary judgment, and I note at the start that although each party puts its own spin on the application of the law to the facts in this case, either party has argued that there are genuine issues of material fact that need to be decided by a trier of fact at trial. Under ORS 192.431, the court has jurisdiction to enjoin a public body from withholding records and to order the production of any records improperly withheld from the person seeking disclosure. And the court makes that determination de novo, and the burden is on the public body to sustain its action. Some background facts submitted by both sides to this dispute merit stating at the outset. Portland residents can create autonomous organizations within a geographic boundary and obtain formal recognition by the city. These groups fall into the classification of neighborhood associations and district coalitions. Both allow residents to weigh in on issues affecting the livability and quality of their neighborhood. The difference is that a coalition encompasses a larger geographic area and therefore contains several neighborhood associations, and from my perspective, as argued by the plaintiff, is performing a key government function in communicating with its citizens, that is, the neighborhood associations, to the point in which the city has entered into taking over that role in a number of instances, including now that SWNI is defunct. The district coalitions are contracted by the city to provide training, orientation, and information, and the city provides grant funding to the district coalitions, which then distribute a portion of the funds to neighborhood associations within its geographic boundaries. There are 7 district coalitions with two different formats. 4 are independent private nonprofit entities, and now 3 are staffed by city employees. SWNI was one of 5 independent private nonprofit district coalitions, but in March 2021, the city defunded it and discontinued its contractual relationship with it due to irregularities uncovered in a city audit. As a result of this change in circumstances, the city took over SWNI's role in the southwest portion of the city. All 95 neighborhood associations in Portland are private entities, and neither side contends that neighborhood associations are public bodies for purposes of the public records law. In this case, the defendant SWNI argues that it is not a public body subject to public records laws. As both parties have argued, the seminal case in Oregon that addresses when a private entity is the functional equivalent of a public body, and therefore legally a public body for purposes of public records laws, is Marks versus Mackenzie High, a Supreme Court decision. In that case, the Supreme Court adopted its own version of what the federal courts had called a functional equivalent analysis. And we hold that the determination of whether a particular entity is a public body within the meaning of ORS 192.410.3 will depend on the character of that entity and the nature and attributes of that entity's relationship with government and government decision-making. I find, as debated by the parties, that under this analysis, the question should be determined at the time that the public records request is made. Pursuant to the framework created by the Supreme Court in Marks, I find that SWNI, although a private entity, is the functional equivalent of a public body and is subject to the public records laws during the relevant time frame. I hear some keying, so whoever that is, if you wouldn't mind muting yourself, that'd be great. The Marks Court stated that in determining the proper characteristics of characterization of a particular entity, the following factors, which we've synthesized from the case law discussed above, are relevant, although no single factor is either indispensable or dispositive. I will review each of those factors in turn as applied to this case and explain the basis for my ultimate determination in SWNI's favor. First, the entity's origin. The parties agree that SWNI was privately created, but also agree that it was created because the city passed an ordinance allowing recognition of such entities and providing funding in order to allow for more efficient and effective communication with neighborhood associations on issues of livability. SWNI was created by community members in 1978 as Southwest Neighborhood Information, Inc., and was assumed by current SWNI in 1997. It is a nonprofit public benefit corporation registered with the Oregon Secretary of State. SWNI is a privately created entity, but it was formed at the encouragement and behest of the city as a part of its scheme and with city funding to address a communication and representation need that the city felt because of its unique form of government. Therefore, from my perspective, this factor weighs evenly on both sides of the scale and is neutral. The second factor is the nature of the function assigned to and performed by the entity. Functions performed by SWNI are similar to other private, civic, and charitable organizations designed to improve local neighborhood communities. These organizations serve the needs of the community as well as the needs of the city. This is demonstrated by the fact that the city has taken over this function in the case of 3 of the districts, including SWNI's former district. SWNI does establish its own bylaws, and those bylaws indicate that its purpose is to encourage, support, and coordinate civic participation in matters affecting livability. As stated by the DA in another matter, district coalitions organize residents and advocate with the city on behalf of their membership. Plaintiffs argue that SWNI fulfills a role of conduit of communications, a role it says is a government function traditionally filled by government employees such as press secretaries and public relations staff. They fill this role in effect as a public government function. This may not be a traditional government function, but the concept of what is traditional is a flexible one that changes over time and over geographic reasons and depending on the forms of government and location. Because of Portland's unique organization, this is a role, that is that of the district coalition, that has been filled by government employees in 43% of the city's geographic areas, in order to fill a need the city sees as essential where the traditional private organizations have failed to fill this need. The city has stepped in and taken over this function in the 3 city-run district coalitions, and that weighs in favor of the plaintiff. Therefore, different aspects of this factor weigh equally in favor of both parties, and it is neutral. Third, the scope of the authority granted to and exercised by the entity. SWNI did not have authority to make binding decisions for the city. In fact, it represented the views of neighborhood associations in their district in attempting to influence the decision makers in the city. Therefore, under the Marks analysis, SWNI was limited to making non-binding recommendations, and this factor weighs in favor of the defendant. However, I will note, as a side note, that is not dispositive of my determination that what we're debating over is accessing public records to determine how public funds were spent, and in that regard, SWNI made its own decisions that are being scrutinized by the plaintiffs in this case with the use of those public funds, or at least those are the allegations which they wish to pursue and investigate. Number 4, therefore, under the Marks analysis, I find that this factor probably weighs slightly in favor of the defendant. Number 4, the nature and level of government financial involvement with the entity. The city provides grants which comprised approximately 85% of SWNI's funding and in some cases 100% of other coalitions. Therefore, this factor weighs in the plaintiff's favor. Factor number 5 in the Marks analysis, the nature and scope of government control over the entity's operation. District coalitions are required to meet certain criteria to be recognized by the city. SWNI ran its day-to-day operations and made day-to-day decisions without oversight or control by the city. The city did not directly control SWNI, but it had a contractual relationship with SWNI that gave it significant influence and control over SWNI's operations. This tension played out in the decision of the city to terminate its relationship with SWNI. SWNI did in fact operate independently, and in its independence, SWNI failed to hold up its end of the bargain. Consequently, the city exercised its greatest form of influence and control by defunding SWNI and then stepping in to take over its functions. SWNI may continue to exist on paper, but it effectively can no longer carry out its mission without the recognition and funding of the city. On balance, I find that the degree of the city's influence and control over the operations and continued existence of a district like SWNI tips this factor in favor of the plaintiffs. 6, the status of the entity's officers and employees. As indicated, SWNI's employees during the relevant time period were not government employees. However, the parallel organizations in the city-run districts do have public employees. Therefore, this factor weighs equally for both sides and is neutral. In summary, many factors are neutral, and more factors weigh in favor of plaintiff than for defendant. But as the Marks Court's caution, no single factor is either indispensable or dispositive. On balance, my analysis leads me to conclude that SWNI should be viewed as the functional equivalent of a public body because of the degree of the city's functional control over the operations and the continued existence of SWNI, and because of the city's fundings of most of its operations. The nature of the city's indirect operational control and financial support suggests that SWNI was a mere surrogate of the city itself. This is most clearly demonstrated by the ultimate demise of SWNI. As at least the demise of its mission, it may still exist, but as I indicated, its role is no longer viable because the city took over that role, defunded SWNI, and ended its recognition in light of SWNI's dysfunctional operations. This is further highlighted by the fact that the city already served the same function itself in 2 other districts. I'm therefore granting summary judgment to the plaintiff and denying defendant's motion for summary judgment. To be more specific, in reviewing the complaint and the requests and the cross motions for summary judgment, here is what I'm granting of plaintiff's requested relief. Declaring that SWNI is the legal equivalent of a public body for purposes of the plaintiff's public records request. Declaring that SWNI improperly withheld the public records from the plaintiffs. Ordering SWNI to produce the withheld public records within 30 days from today. Pursuant to ORS 192.431, awarding plaintiffs attorney fees and costs to be determined in accordance with ORCP 68. What I am not granting is plaintiffs' request that I declare that all district coalitions of the city are public bodies. That may follow from the ruling that I made today, but that would be inappropriate for me to do given that the city of Portland and those other coalitions are not a party to this lawsuit. and I have confined my ruling to the facts established by the parties in the context of the current cross motions for summary judgment. And I would ask plaintiff's counsel to prepare the proposed form of order. Thank you.
Thank you, sir, Your Honor. Thank you.
Have a good day.
Okay, thank you, Your Honor.